for students and faculty members from various institutions to come together, research, and place their valuable views on the topic of today's conference. 3 decades ago, law and economics was a very rough and tumble discipline. As long as legal scholars have to worry about the consequences that a new law brings, we shall call upon the tools of law and economics. At its foundation, law and economics is an empirical discipline and always has been. The most prevailing view among those who predict the future of law and economics is that it will become more technical, more rigorous, and more mathematical, just like its mother discipline, the economics. Because so many people believe that this high-tech trend is the inevitable direction of law and economics, let's briefly understand the logic and the evidence supporting this prediction. The logic is the law of decreasing marginal returns. Having exhausted the pool of basic legal issues that law and economics can illuminate, scholars in the field now need fancy machinery to reach the higher hanging fruit. Simple intuition will no longer suffice to harvest new discoveries. State-of-the-art social science is necessary. There is some evidence consistent with the high-tech trend. For a while, law and economics did become more technical and methodologically sophisticated. The economics discipline has become more rigorous and technical, and as the engine of law and economics, it has been pulling the field to the dizzying heights of advanced math and statistics. While the high-tech trend has been part of the story, I think the future of law and economics lies in increasing its audiences, the users, the researchers. The field's meteoric success since its early days in Chicago is a result of the broad appeal it had among those not formally trained in economics. True, sophisticated economists reinforce the foundations of the field by combing through the earlier discoveries and separating the wheat from the chaff. This growing class of social scientists, I'm sure, will continue to refine and make more credible this body of incrementally growing knowledge. But the future of law and economics is in taking its mature discipline and stock of ideas and exporting them to new frontiers. The big challenge that law and economics have to conquer is to descend from the sterile academic debate and be more successful in informing actual lawmaking and lawyering, in connecting with audiences that have so far remained outside its scope of influence. It should begin to expand to areas of law that have largely resisted it. For example, immigration law, education law, the local government, and even areas of international and human rights law. Many areas of recent legal reform, health law, food regulation, consumer law, privacy law, have major pockets of laws and rules that are ripe for more informed attention from law and economics. We are witnessing a rise of experimental law and economics, of sophisticated behavioral analysis, and of course, of a mature empirical methodology examining a plethora of legal topics. I'm happy to note that today, economic thinking dominates contract, commercial law, bankruptcy, antitrust law, corporate law, and securities law, and allied fields. It is also influential, if not dominant, in tort law, criminal law and property law, and even in civil procedure. It is perceived that it has made little progress in the major fields of public law, including constitutional law, immigration law, administrative law, and international law. Maybe these areas of law are less closely connected with commercial behavior than most of the others, and so the off-the-shelf economic models do not as clearly apply to them. But I'm happy to note that this is changing. In the last few years, a new generation of law and economics scholarship has focused on these fields. Scholars see international law as a product of interaction among self-interested states. They analyze administrative law on the basis of agency models that emphasize the divergence of interest between the principal and the agent. Constitutional law can also be understood using agency models where the people are the principal and the government is the agent. Immigration law can be understood using screening models from the economic literature on labor markets. The first stage of research in law and economics, what we all know, was mainly theoretical. Economists and lawyers used and adapted concepts and analysis from economics to show that legal rules and doctrines often had a clear economic rationale, and to show how these concepts illuminated how laws and legal systems affect behavior and the efficiency of economic outcomes. These early studies had an enormous influence on how some lawyers and economists began to think about property, contracts, negotiations, trials and settlements, torts, antitrust, corporations and securities, crime, even racial and gender discrimination and other areas of law. Yet it took a while for these ideas to spread into law schools, since academics and other lawyers initially had little exposure to the economic way of thinking. Partly for this reason, considerable opposition developed to many of the ideas espoused by the economists and other pioneers in law and economics. Gradually, however, the opposition weakened as newer generation of lawyers became better qualified to appreciate and evaluate the contributions of this new field. Law and economics developed as the study of the traditional first-year law school issues of torts, contract, property, criminal law, and procedure. These are the first-year law school courses because they are the building blocks of other areas of law. It was a smart place to start. The central problems facing society today, however, go well beyond these building blocks. They are highly complex. Structural problems and knowledge of the building blocks will not be sufficient for addressing them. If we were to list some of the central problems or areas of law facing us today, we would list areas like banking and finance, poverty and inequality, development, education, healthcare, energy, and the environment. Scholars need a deep understanding of the building blocks, but they also need to understand the institutional, economic, statutory, and political structures of these problems. And because of their complexity, the techniques we use to study them might be different. We will far more likely to have to work with experts in these fields. In fact, I have been insisting that the co-authorship with people from other departments of the university may need to become the norm. Models will have to be more complex. Data requirements will be greater. The problems involve less law in the sense of what courts do and more of policy in the sense that statutes and legislatures will be central. So there are, of course, people currently working in these areas equipped with all of these tools, but the concern is that their numbers are very limited. If law schools have to contribute to the great problems of the day, the scholarship will have to move in this particular direction. I believe conferences such as this will contribute significantly to developing scholarship in this niche branch of law. Hence, I take immense pride in inaugurating the 5th International Conference on Law, Economics, and Public Policy. My very distinguished colleagues, Professor Anita Nagar and Dr. Hitesh Thakkar, have put in their best efforts to identify and bring before you very eminent scholars in this domain. I'm confident that these resource people, the experts, will enrich you with the domain knowledge and will also expose you to all those challenges and opportunities in this domain. I wish this conference a grand success and wish all the participants a very enriching and engaging experience. I thank the organizing team for giving me this wonderful opportunity to know and interact with all of you. I once again thank each one of you for joining us today. Wish you all the best and thank you so much.
Thank you so much, sir, for your valuable words. I now invite Mamta ma'am, Dean Academic Affairs, to please deliver the welcome address.
Thank you, Isan. First of all, my apologies for the delay. There was some technical issue and madam is also facing, I think is coming. So good morning to all of you. Honorable Chief Justice, Justice A.K. Sikri sir, former Judge, Supreme Court of India. Honorable Guest of Honor, Mr. Sanjay Prasad sir, Chief Election Commissioner, State of Gujarat. Honorable Director, Professor Dr. S. Santakumar sir, my colleague, Professor Dr. Ranita Nagar, the convener and head of this Center for Law and Economics, Dr. Hitesh Thakur, the member of the center, the student members, my colleagues from academics and administrative department, research department, and participants and dear student and his son. It is a privilege for me to speak few words in the inaugural session of this conference. One is because of this very emerging area of the law and economics. Many times I say this that when I see from the law point of view, I see that both are parallel lines and how to bring together these two. That is a very tough work for the people. But I'm very happy that Gujarat National Law University through the Center for Law and Economics is attempting, and I think the last decade they have proved in doing many cutting edge research in this area. And coming to this topic, because I was told to speak few words about the conference. When I see law and economics, then I see that it is nothing but the economic justice or economic benefit through a law. Now the Indian legislation or the Indian legislative history, I think is very evident that we have plethora of laws where economic elements are there. But the very serious concern today is that the main focus, always the main focus of law is justice. But as I said, that last few decades, the attention has been diverted to economic justice. It can be Constitution of India, it can be family law, the various personal laws, it can be commercial and business laws, the different branches of labor law, consumer protection law, finance and banking law, gender related law, but particularly when we talk about law and economics, I think there are specific areas of law where the it can be looked into under the lens of the economics. For example, very recently there was a judgment by the Supreme Court of India extending the legal rights of a daughter in the inheritance property prior to the Succession Act 1956. and which was a very, if we read that judgment, that the sole daughter who was survived, and the issue was relating to the father's property and prior to the Succession Act. But the judiciary intervened in a way that yes, the sole surviving daughter is entitled to that property of the father, and that is nothing but economic justice to the daughter. Yes, it is the interpretation of law, and the Supreme Court interpreted in a very different way. But the very interesting point that the debtor who was not having any right in the co-personary property or the other property, so there the Supreme Court extended this right of the debtor, that even he is entitled for that property prior to the Succession Act. So now in that background, I just want to say that in my experience, that any law in India, it becomes very strong and very efficient by the factors like legislative backing, then judicial intervention, and executive action. And now this new branch that we see, that interdisciplinary, and particularly in the area of the law and economics, where we can see the economic benefits and economic justice. I don't know, I may be wrong also, but when I look at those laws, then I see that by applying the economic principles to the legal principles, one cannot one cannot enlarge the area of justice, because that is the interpretation and application of law. But by applying the economic principles, I think the more economic benefit can be provided. And that should be the spirit of this particular research area in law and economics. Like when we examine the various laws, like the commercial and business law, particularly the recent legislations like insolvency and bankruptcy code, and various financial market law. So when we look at these areas of insurance sector law, banking sector law, securities market law, then pension fund, which are the prominent areas of financial market law, I think there is one requirement, or there is a gap where this particular branch of research can help identifying the gap, that how economic benefit and economic justice can be provided, and also that ultimately will help the economy of the country. Coming to the other branches of business law, like the MSME sectors, then the labor laws. Very recently, there was a judgment again by the Supreme Court of India, that was relating to this amendment, 97th Amendment of the Constitution. The case was Union of India versus Rajendra N. Shah. That was a case relating to this cooperative societies, the certain changes, and through that amendment, the constitutional validity of that amendment. So in that judgment itself, this particular economic benefit, and how these cooperative societies are helping in the economy of the country, and the citizens, individuals. So that has been explained very well, though the judgment is very different, that because of certain very important technical requirement, the judgment came differently. But it shows that the judiciaries and the legislature, they are also showing some interest towards the economic benefit legislations. I think in the last conference also, I was sharing few elements in the Companies Act, like the concept of the producer company, the related party transactions, then the this many other areas where some economic element can be brought. So my point here is that the law and economics is not just to criticize that this law is not beneficial, economically beneficial. No, the main purpose of this research should be that where is the gap, and identifying that gap. How can we bridge the gap and help the country in the policy making, that a new policy can come and help the people and the country in the economic aspects. So there are various areas, and particularly when we look at the legislations and the judicial interventions, then we will see that how the judiciary is very prompt and active in providing justice and economic justice. So starting from the personal laws, when we look at the personal laws maintenance, you just see starting from Sahabano judgment to Daniel Latifi and Lily Thomas. Everywhere it is nothing but economic justice to the women in India. It was not about that whether this group, that group. If we read very detail those judgments, then one can sense that what kind of economic justice also is provided. Then coming to the other law, because I don't want to discuss when Honorable Justice A.K. Sikri sir and Honorable Chief Commissioner, Election Commissioner Sanjay Prasad sir are there to speak on that. So very recently, I was also teaching my students this concept of the related party transactions and avoidance of transaction under Companies Act and yeah, Insolvency and Bankruptcy Code. So there I could see that yes, there is a scope and chance that some economic benefit can be provided. So when all such concepts are there, that is not economic benefit to a wife or a daughter like the personal laws, but this is economic benefit to the company, to the shareholder, to the creditor, and to the country at large. Because the corporate entities nowadays in India, if you see that they are very, the number I think will be after few days equal to the citizens of India. So there also is a very big scope that the law and economic analysis can be done. Like the recent developments, all of us know the 2021 amendment to the Insolvency and Bankruptcy Code, where the pre-packaged insolvency resolution process was introduced as a new concept, and that is only for the MSME sectors. That before you go for CIRP, one chance can be given, and you can resolve your this default, that non-payment of the debt or the outstanding debt which is defaulted, that MSME sectors can also solve. So these are few area that legislature also is very active, and judicial intervention, it is very evident from the beginning when all these commercial laws were not developed. Constitution, when you look at Article 21, how the Supreme Court has enlarged the scope of Article 21. In various judgment also, some elements of economic benefit, economic justice is there. So that while concluding, my understanding is very limited in economics, but I can say, and I can also very strongly say that how this research is developing in our country. And I feel very proud personally, the Gujarat National Law University and the Center for Law and Economics, they are very active in this area. And when I see very recently last week, when the discussion was going on a SEBI discussion paper by the center, then I could see that yes, it is a small group, but they are capable of doing so many things. And that is there. I want to congratulate Madam, my friend Dr. Nagar, and my colleague Dr. Hitesh Thakur, that very strongly I can say today that after 10 years, I think this there will be some paper that your recommendations will be there to the country, the government of India, that how economic benefit and economic justice can be the part of our justice delivery system. That is what my understanding about law and economics. And with that, I thank the center head, madam, and the member and everyone for giving me this opportunity. And this is a learning session for me because I am a layman about the economics, so that I will try to understand that how law and economics will bring all these solutions and economic justice. Thank you very much, and congratulations, Madam Hitesh sir, and all the student members, Isan, everyone. Thank you very much.
Thank you, ma'am, for your inspiring words. We now have Professor Dr. Ramanta Nagar, Center Head, GNLU Center for Law and Economics with us. I now invite her to enlighten us about this edition of the conference.
Thank you.
Ma'am,
Thank you,
please.
Ishan. I'll start with profound apologies to Honorable Justice Sikri sir and Prasad sir, and of course, Director GNLU and Dean and my entire team. There were some connectivity issues, but finally, it's been overcome. Good morning, respected Director, Gujarat National Law University, Professor Santakumar, respected Dean Academics, Professor Dr. Mamta Biswal, respected Justice Sikri, former Judge, Supreme Court of India, and Chief Guest of this conference. Respected Sanjay Prasad Sir, Election Commissioner, Gujarat, and Guest of Honor for this conference. Dr. Hitesh Thakur, Assistant Professor of Economics and Convener of the GNLU International Conference on the 5th International Conference on Law, Economics and Public Policy. Respected faculty members from GNLU and from universities across India, scholars who are presenting their papers at the conference, and dear students, I wish you all a very good morning. As I understand, there are two causative factors that have shaped outcomes in every society across the expanse of history, and they are institutions of economics and institutions of law. There are two foremost responsibilities also of a premier university. The first is to capture the important questions and challenges faced by a country in dynamic times in terms of research papers. And the second, and more important, is to impart the most scientific tools in order to capture these questions accurately and arrive at efficient solutions. In this regard, this particular conference has been envisaged, wherein we have the process that started. The process was very, very strict. We did not ask for abstracts. We asked for full papers. So that is one benchmark that we have set for ourselves. Full papers, we had 76 full papers coming in, which went through a review process, out of which 33 papers are being presented in this conference. We have 8 technical sessions for the conference, and the technical experts come from universities across India, IIT Kanpur, IIT Patna, IIM Ahmedabad, National Law University Jodhpur, National Law University Tamil Nadu, just to name a few. The broad areas that the papers cover are the throbbing issues of the time. They are they are COVID and health issues. They are unemployment. They range from public law to private law to constitutions, which have emerged as a savior in terms of using their emergency powers during the COVID time. It takes into consideration important financial and banking concerns. So expansive theme, all themes highlighted. So those are the contributions that come from the technical experts. And in this process, we have aspirational standards wherein we look beyond what is available at the national level, and we take learnings from the global authorities in law and economics who participate as plenary speakers. In this conference, we have plenary speakers like Professor Stephen Voigt from the University of Hamburg, Professor Ginsberg from the University of Chicago, Professor Ram Singh from Delhi University, and we So that is the expanse of plenary speakers that we have for this particular conference. And all of this goes on for one particular purpose, and that purpose is to bring this domain and training of this subject, which as we know is nascent. It was 1990 when India went on for the new economic policy, wherein we had this tectonic shift as far as economic and legal framework is concerned. This itself has given rise to huge tectonic questions and challenges in terms of disease, unemployment, war, to name a few. So the ground is very fertile, wherein the consequences of the law and policy are seen, are visible, huge improvements as far as growth is concerned, huge questions as far as the issue of development is concerned. So point is a very, very fertile ground for the young scholarships to deliberate on these questions and deliberate on them not only from a theoretical perspective, but also to come with a scientific understanding. And law and economics is a tool to create this scientific understanding, and based on that also therefore give scientific solutions. This is the journey that GNLU has been on for the last 10 years, as my very good friend and Dean Academics has pointed out. We take great satisfaction in the fact that this niche area of emerging scholarship has a huge presence of the GNLU Center for Law and Economics from these platforms. You'll be happy to know, Sikri sir and Prasad sir, that when we started, there was a small, the interest was limited. Now the interest, as you see, is expanded. And therefore, continuously there will be an impact, as Santa Kumar sir, our director, said, that it will impact policy. We've gone into now, from again the enthusiasm of student members, we are looking at consultancy papers, and we are putting in our inputs there. So all of this is a world of law and economics that we have created with everybody's inputs. Professor Bimal Patel, who started this during his tenure as director, the present director and the entire administration, which is completely supportive of this. The Dean Academics, who makes it very clear that, okay, you are crossing disciplines, but be correct in doing so. That's her benchmark in academics. Don't just cross over, but cross over correctly. So that's the standard she maintains, the checks and balances she maintains. The students have remained the energy over so many years. The technical experts from across the world have been eager friends. As I said, the global authorities have been with us as our aspirational learning. And in the core of all this is one person who has taken this responsibility squarely on his shoulder. Even today, when I think I created the maximum confusion, and that is Dr. Hitesh Thakkar, very continuous, very responsible, not just limited to arranging conferences, but also very noted publications in the world of law and economics. So, so this is the aspiration of consecutive conferences. I detailed a few contours of this particular conference also. And with that, I will conclude. We want to hear from Justice Sikri and Prasad sir. I will conclude with wishing the conference all the best. Thank you.
Thank you, ma'am. Thank you so much. Moving forward, it gives me immense pleasure to welcome our guest of honor, Shri Sanjay Prasad, State Election Commissioner for the state of Gujarat. Sanjay sir is a 1986 batch IAS officer of Gujarat cadre. In his illustrious career spanning decades, he has worked in multiple capacities across various departments with the government of Gujarat. At present, he is the State Election Commissioner in Gujarat. I now invite him to please address us.
Thank you, Ishan. Respected Dr. Justice Sikri, former Judge, Supreme Court of India, respected Professor S. Shanta Kumar, respected Dr. Mamta Biswal, respected Dr. Ranita Nagar, Sri Hitesh Thakkar, and all colleagues, friends and students of Gujarat National Law University and participants in this seminar. It gives me immense pleasure to be here today to uh, participate in this discussion, even though I am a generalist and such distinguished panelists and speakers are there. So it's with a great deal of trepidation that I venture to say what I'm going to, because I know that I may be crossing barriers and making statements which may not be very mainstream in that sense. Now, my basic theme is that law and economics is not a new discipline. We think that law and economics is a new discipline or subset from economics from 1890s, some say, or some say 1920s, some say 1970s. But actually, economics was originally law and economics. What Aristotle in the Greek philosophy, he expounded so many principles. Then the Roman state came and codified all this. And the first book on law and economics is from India only, which everyone seems to have forgotten. This book, Arthashastra, more than 800 pages. It is a treatise on economics and it is nothing but law and economics. So law and economics is something which has been with us. Then the medieval Europe, the scholastics, Thomas Aquinas and others, they had a lot of insights into utilization of property and wealth. Then during the Enlightenment, Adam Smith, David Hume, I'm only taking some of the names just to show that it's a very traditional thing. And Max Weber, and then the German historical school, all these people have been talking about law and economics. And economics was earlier called political economy because it studied politics along with the economy. Without politics, there could be no economics. And law is basically the codification of the political and social processes in an institutionalized form with an institutionalized structure to implement it. That is the legal structure and the laws. So law and economics has been with us right from the start. Now, recently, if you say from the 19th century onwards, the institutional economic school started and the German historical school started, and they studied the economic principles in the historical specificity and the cultural specificity of that area and the type of institutions that were to implement it. And that Thornstein Veblen, for example, said that economics should be historical, experimental, and empirical. So that was the mainstream economics at that time. However, economics became more and more mathematical. It went into more and more abstractions. The theories of Walras, Marshall, Samuelson, you needed to study trigonometry to understand economics and various areas of different triangles and curves, etc. Now, that aspect became quite divorced from reality. The real life of the people who are struggling to feed their families and to have 2 square meals a day, educate their children, and all these indifference curves and marginal utilities. So it led economics towards marginality and towards indifference also, I would say, because it went into so much abstractions which were never verified on the ground level, whether those abstractions were there, that man is a totally rational animal and that everyone has full information about all the decisions that he is taking. All these were very questionable assumptions, and the total faith in the market structure. We all know how the market structure collapsed in 2008, and all those pundits who were coming out with new theories about markets and new financial instruments, what was the result for the whole global economy? So this modern law in economics, which again started from the 30s, we can say, with Ronald Coase and the social cost benefit analysis, transaction costs, and new institutionalism, behavioral economics, and Richard Posner, and with his economic analysis of law, all those things went back to the basic principles of political economy which the Enlightenment had. With Enlightenment, the basic feature was that it combined ethics with economics. There were some moral foundations of economics. With all the mathematization of economics, the moral principles, the ethical foundations of economic behavior went into oblivion. So now with the law and economics movement is again bringing it back into focus. And law and economics has a very vast field. It has land laws, tenancy laws, employment laws. Why some areas in India are agriculturally and socially backward? Because the land laws in those areas have not been codified properly, they have not been implemented properly. Then labor laws, migration, gender, social justice, which is a very big field, to give redistributive justice to the deprived sections of society who have been socially oppressed also. Gender issues are there, the rights of women, along with trade contracts, consumer protection, debt relief, financial laws, bankruptcy laws, tax policy, grey economy, cryptocurrency, criminal laws, corporate laws, cyber laws, privacy laws, telecom laws, constitutional laws, election laws. So it's a very wide field, as wide as society itself. And law and economics has very wide relevance. It overlaps with philosophy also. What is the legal philosophy of law? What is the background of the laws? It interacts with culture, how those laws can be implemented in society, with institutions, the specific historical situation of society. And it has so many aspects on regulation, taxation, subsidies, a lot of policy implications. Then a lot of issues for redistributive justice. Just now, the worldwide trend is for very increasing inequalities. How can that be affected with affirmative action, equity, gender, education, health? You are all aware of the COVID situation and the steps the governments have to take to deal with it. Environment and climate change, the kind of steps which the governments are taking to tackle climate change, go for clean and green energy. So all this impact of laws on economic behavior, which has impact not only on economics, but for the future of the planet itself. All these things are covered under law and economics. And it also emphasizes the institutional structure of society, the culture of society. And the fields for law and economics are very big. The analysis of policies, the analysis of technological and organizational innovations. Society is never static. It keeps evolving. New organizational innovations come, new forms of technology comes, as you are all aware of this cyber technology, IT revolution, etc. So all these need to new regulatory practices are required, new regulatory institutions are required. So law and economics is not something that can never become obsolete, because it will always keep evolving. Human society has evolved from the Paleolithic ages to Neolithic, agricultural, industrial society. Now we are going into post-industrial society. So with each transition, there are new issues are coming up and new challenges for law and economics will come up. Now I want to emphasize one thing, that we all talk about law and economics, and as I said, that political economy and economics, all that has been very old and with us. And so law and economics is a mainstream subject. Only in the recent past it has evolved out of the mathematical economics, so we think that it's a new subject, but actually it's been with us for a long time. But the concept of justice, when we talk about law, the concept of justice cannot be far behind. And here I would say that the economics has been obsessed with the Pareto equilibrium and that neo-marginal economics equilibrium theories, which are based on all kinds of assumptions which are not really borne out by the actual behavior of societies and human beings. And the welfare concept which emerged also, mainstream welfare concept, came from the utilitarians, that Bentham, who said the greatest happiness of the greatest number. Now, it has a lot of issues. Firstly, the interpersonal comparisons of happiness are very different. If one person who is economically very well off and he wants to have ice cream for dessert every day, and that makes him happy, and another person who has nothing to eat and one chapati or two chapatis will make him happy. Now, as far as the Benthamite structure is concerned, both the things are the same, and you have to give them equal weightage. So all this is ethically, a lot of questions are there. For example, we have in India or worldwide also large amount of involuntary displacement of people, because some people have to suffer. So all these issues have become questionable now, and the alternative has been the tendency towards affirmative action. Our Indian constitution has huge chunks of affirmative action in it for the people who are economically, socially backward, for women and children. So many exceptions to the rule of equality have been given so that affirmative action can be given to the deprived sections. And Gandhi's talisman is there. Our constitution's preamble is there, which are the guiding principles for the affirmative action. Then John Rawls in the Western philosophy, he has come out with this whole concept of affirmative action, and for the efficiency can be balanced with seeing that the poorest and the most deprived get the benefits. So all these are very important concepts which I think the law and economics movement also should tackle. And now the concept of limits to GDP and the concept of a hedonistic standard of living happiness is there. And I think, as I said earlier, the Arthashastra, that book written by Kautilya or Chanakya, that gives us a good index that has a welfare state as an ideal, and it has 15 books, 150 chapters, 180 topics, and it talks basically about a welfare economy and how the state has to create a welfare economy. At the same time, it talks, legitimizes private property also, but state enterprise is also there along with that to see that the welfare of the people is ensured. And that has a lot of topics. I will just read out some of them, which will give you an idea that it is actually a treatise on ethics also, and law and economics also, value of money, classification of commodities, weights and measures, conciliation and arbitration, state, territory, population, administrative structure, relief measures to be taken for during calamities like fire, flood, famine, epidemic, infestations, warfare, brigands, like employment, provision of employment, which the state is doing now, and provision of food free of cost, use of common land pastures, settlement of virgin lands, promotion of economic activity. Large number of things are there. I don't want to read it. I mean, but the concept is that in Indian tradition, we've had this concept of law and economics and welfare economics and affirmative action right from the start. That is the reason why in 1950, when the constitution was adopted, affirmative action was made a part of the constitution, though in Western philosophy, it came only in the 70s, the concept of affirmative action, and in the West with the black movement and resistance movements. And those concepts came later. So it's not that we have adopted these things from the Western philosophy, but from Indian philosophy itself, they have come into it. So I think all these tendencies, the law and economics should be an interdisciplinary research. It can have components of IT, commerce, mathematics, sociology, anthropology, psychology, political science, philosophy. So it's not only two disciplines, law and economics, but law, economics, and other social sciences and technical sciences also need to be integrated. And the policy making of law and economics is immense, the contribution that can be made, because as society develops, new challenges emerge, new problems emerge, and we can look into the future. What are the emerging trends? What are the emerging problems? And after 5 years, 10 years, 20 years, these will become very dominant. So how they can be addressed and what changes in policy laws can be made to see that we can adequately tackle these issues. So though it is an empirical subject, it is also a philosophical subject, I would say, and it requires a lot of intensive research, empirical research, as well as conceptual research. And I'm sure that GNLU, with a vast array of interdisciplinary research and enthusiastic students and very committed faculty, and GNLU also has the advantage that it interacts with large number of civil society organizations and other academic institutions. So I think GNLU is very well placed to take the lead in this reorientation of law and economics, but I strongly feel we should not be defensive about law and economics. It is the basic economics. The mathematical economics came later, and the limitations of mathematical economics are very clear to everyone, how abstract and theoretical and divorced from reality it has made economics. So I think that aspect is very strong base for law and economics is there. And I congratulate Dr. Nagar, Dr. Biswal, the entire team, Dr. Thakkar, for having this great conference, and a very high level of panelists is there, and good discussion will take place and good policy inputs will emerge from the debates that are generated with these discussions. Thank you for giving me an opportunity to share my views, though they may not be mainstream economist views, but I think very strongly that we should think about justice, philosophy, all these things have to be brought back into social sciences, into law, into economics. Thank you very much. Thank you.
Thank you so much, sir, for your inspiring words and insightful words and gracing us on this occasion today. Moving forward, as a student of law, it is a matter of immense privilege for me personally to welcome our chief guest, Justice Dr. A.K. Sikri, former judge of the Supreme Court of India. Justice Sikri pursued his LLB in the year 1977 and was a standout candidate throughout his years as a student. He enrolled as an advocate with the Bar Council of Delhi in the year 1977 and started practicing there. In the subsequent years, Justice Sikri came to represent numerous institutions as well as corporations, and also served as the Vice President of the Delhi High Court Bar Association. Justice Sikri was appointed as a judge of the Delhi High Court in July 1999 and has also served as acting Chief Justice of the Delhi High Court and Chief Justice of the Punjab and Haryana High Court. He was elevated to the Supreme Court of India on April 12, 2013, and while on the bench, both at the High Court level as well as the Supreme Court level, Justice Sikri has been a part of many notable decisions, and his contributions to the field of law are a testimony of his hard work and wisdom. Justice Sikri will be addressing us today on the role of judiciary through a law and economics perspective. I now invite him. Sir, please.
Thank you, Ishan, and good morning to everybody. I thank Ranita ji for inviting me in this international seminar of great eminence and importance. Shri Sanjay Prasad, Professor Shanta Kumar, Professor Mamta Biswal, Dr. Thakur, Thakkar, and all others who are present, including my dear students. As is told to you by Ishan Gupta that my role, I would be limiting it to the role of judiciary in my talk, insofar as connect between law and economics is concerned and economic considerations in decision making, judicial decision making are concerned. I would say two things at the outset that of course, it was earlier, the program was to finish at 10:45, and as I have one arbitration matter at 10:45, but then Ranita ji said that it may spill till almost 11. I said okay, so I requested the parties to wait, and I'll be joining at 11. So I may not be having much time, and what I wanted to say may not be able to say all that, but at the same time, another comment which I want to make is that my task is made easier, particularly by Shri Sanjay Prasad in his illuminating address. And he has covered most of the aspects which I wanted to cover. And again by Dr. Mamta Biswal as well. What she has said, much of that I wanted to say. Of course, the address of Professor Shanta Kumar was also excellent, and his main thrust on the mathematical economics, etc., which to some extent in his own inimitable style, Mr. Sanjay Prasad has differed. So all that I need not discuss, which I wanted to discuss. And I will be confining myself to next few minutes only to the role of judiciary. I may say at the outset, and as Dr. Or Mr. Sanjay Prasad has rightly mentioned, we are, when it comes to law and when it comes to role of judiciary in enforcing the economic aspects of law, it is not obviously judges are not economists. They would not even understand the mathematical aspects of economics because nobody has studied economics in that great depth. But the fundamentals of economics, and as my earlier speakers have mentioned, that almost economic factors arise in almost all kinds of laws, which were highlighted by the speakers. And there are some economic aspects, and I really like the expression used by Professor Biswal was that it pertains to economic justice and economic benefit through law. I think these are the words, economic justice and economic benefit through law. That is the message, and that is what should be kept in mind mind by judges while delivering justice. We know, and as I said, I'm not going into the history which Mr. Sanjay Prasad has about this, our Arthashastra and from Kautilya period, how the law and economics are wedded together, has been stated so very brilliantly. But coming to the present times and how law and economics have been treated as the subjects of arriving at justice. Of course, it is the Posner who retired as judge of the United States Court of Appeal for the Seventh Circuit after 36 years long service, and his contribution in this field is phenomenal. He actually, in his scholarly works, Economic Analysis of Law, he, along with a few other scholars, laid foundation to the influential law and economics movement. And today, law and economics has carved itself into an independent scholastic discipline, being widely employed to make sense of concepts as disparate as the right to privacy, contracts, and others, as were described by the other speakers. And Posner wrote in 1981, and I quote, the meaning of justice. So therefore, the questions which may arise at this point are, when and how do law and economics, rather distinct fields of knowledge, interact with each other and converge? What is the role and purpose of economics in law? How does economics ensure justice impartation, and how it can be used as a tool to understand law? And this two things which become important from the judge's point of view, and when the judges have to examine such issues in every field, as we have seen that law and economics are connected, and whichever field we go, we can see it through the prism of economics, that position of law and the outcome should be like that. And the law and economics, or the economic analysis of law, in that sense, is a theoretical analysis of law based on principles of economics, the overarching principle being efficiency. Of course, rational choice theory, which is the presumption, and much is said about it. But another thing which I would say is that it is the social efficiency, which is again very, very relevant and has to be kept in mind. And so therefore, this as Posner has pointed out in his book, Frontiers of Legal Theory, and if I quote, when it comes to the role of judiciary, I quote, in its normative aspects, law and economic advises judges and other policymakers on the most efficient methods of regulating conduct through law. Now, what in this context, and again, I would say Mr. Prasad has mentioned about that, that R is a nation governed by the Constitution, and India is a constitutional welfare state. When he talks about the affirmative action, he highlighted on that, where one of the most important social goals is the social welfare. Since our country is in the road to economic growth, economic welfare and well-being of citizens, especially the most vulnerable sections of the society, uh, which is an indispensable part of social welfare. So therefore, all the wings of the state, be it the legislature, be it the executive or the judiciary, we have to strive towards this economic growth. We have to see how the country becomes a prosperous, economically prosperous, and how downtrodden, marginalized section of the society and how the poverty alleviation can take place. And Amartya Sen in his book, Idea of Justice, has brilliantly discussed all this. And but what I'm saying is, when the judges and some of the judgments which Professor Biswal had also given, when the judges decide these cases, only thing is, and I'm saying as a part of judiciary, that some of the economic aspects may be in mind, but not consciously, only subconsciously. It has to be brought to the fore, and the judges, while discharging this role, have to keep in mind what would be the economic consequences of judicial decision making. In a welfare state, when the government is taking so many welfare measures, so many public projects and other projects are undertaken, then naturally, and all these cases in respect of many of these, they land up in the courts, and courts decide whether the court should decide purely on the basis of the strict legal or dry legal principles, or keep in mind the economic aspects also. That is what I want to emphasize here. And as I said, that it is not come to the mind of the judges by and large. It is slowly now creeping in that we should keep that in mind. And even if that is there, that is only at subconscious level. Of course, in one of the judgments, which is Shiv Shakti Sugar Limited, Renuka Sugar, about 4 or 5 years ago, the Supreme Court had very categorically mentioned about the importance of law economics. And if I may quote from there, the judicial wing, while undertaking the task of performing its judicial function, is also required to perform its role in economic growth. It calls for an economic analysis of law approach, most commonly referred to as law and economics. The first duty of the court is to decide the case by applying the statutory provisions. However, on the application of law and while interpreting a particular provision, economic effect of a decision, wherever warranted, has to be kept in mind. Likewise, in a situation where two views are possible, or wherever there is a discretion given to the court by law, the court needs to lean in favor of a particular view which subserves the economic interest of the nation. Conversely, the court needs to avoid that particular outcome which has the potential to create an adverse effect on the employment, growth of infrastructure or economy or the revenue of the state. If I may give just few examples that the courts have, steered towards it and have undertaken this task. There was one case of intellectual property. Now, there would be many such cases. I'm giving some example in the intellectual property where it was a case of a design. Pearl Pet filed a case against another company that they were in the water bottles, etc. They were imitating the design of Pearl Pet, and that question came for an interim injunction whether it should be granted or not. So, but what was found was in that case that the other company had employed hundreds of employees in its factories. And if of course, the case was initially discussed whether there is a violation, prima facie at that stage, violation of design law or not. The court found that no, it cannot be said that it is a clear case of violation of the designs of the plaintiff. But then in a situation like this where prima facie case may be there, but then what is the irreparable injury or where the balance of convenience lies? And the defendant had the arguable case and could have said that, look, it is not that it has imitated the design of the plaintiff. So in these circumstances, what weighed with the court in refusing the injunction was that the defendant had employed hundreds of employees in its factories, and therefore granting of injunction at that stage would amount to seizing the production and rendering all those employees unemployed, which should not be. So therefore, these are some of the factors which have to be kept in mind. And when it comes to like public projects, and we know in Ronak International Limited, IVR Construction Limited, the Supreme Court said that if some public project is there, some tender which is awarded, and suppose the tender is challenged by filing a writ petition in the court, grant of award of tender, at that stage, it has to be kept in mind that if the injunction is given during the pendency of that writ petition, how much effect it can have if the petition is dismissed ultimately, or after 2 years or 3 years, the project is to be awarded again, and how the cost will escalate. So these are some of the factors which have to be kept in mind by the judges while deciding such cases. The principle of proportionality, which we have adopted, and one of the judgments which I rendered under the Competition Commission Act, it is under that a person who violates the or indulges in anti-competitive action, the punishment or the penalty is provided under Section 28, which says that it can be up to 10% of the turnover or gross revenue. The question was, a particular company which has indulged in anti-competitive in one field may have 10 companies, and it is one company and a group companies, or 10, sorry, the company is 10 businesses, different kind of businesses. So therefore the question was whether it has to be, how this 10% is to be interpreted, whether it is the entire turnover of the company relating to those 10 businesses, or it has to be confined to one. Applying the doctrine of proportionality, it was decided that where in that particular business where the it is the anti-competitive it was cartelization or which was done, so it should be turnover of that only, because 10%, suppose that in that particular case it was the say 20 crores was the amount, so 10% would come to 2 crores. But if the entire turnover of that company is taken, this was 2000 crores, then the penalty itself will be 200 crores if 10% of that is to be taken. So that should not be. These are some of the aspects which come in the mind, but at the same time, many times it is, and that comes as a criticism, that the courts have not taken into consideration the economic aspects of some of the cases where the judgments may be legally correct, applying the principle of law, but the outcome or the final the directions which were given may not be correct. I give the example of this 2G and coal mining cases. These 2D judgment where the licenses were found to be given wrongly, and we apply the principle of administrative law, which is comes, and on the basis of application of principle of administrative law, the decision is perfectly correct that these licenses were wrongly given. If we look into only from the matter of governance and the why it was done, maybe the all these licenses which are set aside may be treated as technically a correct decision. But the question which arose and which had been debated thereafter for so many years was that, was it necessary for the Supreme Court to set aside all those licenses when these companies, telecom companies, were operating and they had those licenses, they had invested hundreds of crores of rupees in the telecom sector, utilizing that licenses and creating that infrastructure. And today, now, if you cancel these licenses, how much is the effect? So whether the purpose was not could not have been served by asking them to pay more license fee, or imposing penalties on that. So these are issues which arise, and other is about same thing is about the coal mining, where the coal mining licenses were cancelled. It had the devastating effect, and these effects can be on the economy also. Here the question arises on the, again I will say, when the principles of administrative law are applied and it was seen that the coal mines that leases which were given might not have been technically correct, but the whether it was necessary when these the leases which were given to them, and on that basis they were doing business, and steel factories etc which had been established where the coal was needed, whether it was at that time after 4 or 5 years of their operation, whether such a decision was proper, that they should have cancelled these leases, and may have led to all these companies into penury, which had the effect on the economy of the country. So these are some of the issues which arise. But another aspect which I would say, and on which Mr. Biswas has also touched a bit, that there are, we can't have only, I mean, when we apply the economic principles, we can't go by rational choice theory only. We can't go into the this presumption that everybody had made a rational choice, which doesn't happen. And particularly in cases of affirmative actions, etc., in a welfare state, it may not happen. So therefore, there are exceptions to the economic analysis of law, and it is particularly in the cases of altruist behavior by individual in firms and in government. So therefore, this there may be persons with altruist behavior which may not go by such considerations. Kaplov and Chevel, leading scholars of law and economics, have famously argued that fairness, which they take to include any non-welfare value such as morality, justice, or dignity, has no independent value of its own in the design of law and economics apart from its effect on welfare. They contend that the law should pursue its distributive objectives entirely through taxes and transfers, and that there is no reason for non-tax law to concern itself with fairness. So this is some of the I mean issues or the debate which may arise. And another thing which I would like to say here is, and which may be a dilemma particularly for the judges, that is, the challenge is striking a balance between economic efficiency and legal rights. On the one hand, there are legal rights, as I have given certain examples. On the other hand, economic efficiency. So striking of this balance is not easy in any decision making. Courts have to strike a right balance between economic efficiency and equity many times. And so therefore, the courts may have been criticized for perusing equity and fairness at the expense of economic efficiency. But how that is to be done in a particular case, that is the challenge. And some of the cases which have been here, I would only say at this cases, some of the cases where such a challenge has come is where the human rights are involved. Now, take for an example the cases where the Supreme Court passed a few years ago a judgment on banning the liquor vends on highways within 500 meters. So on the one hand, it was, it was in the name of or in favor of that when the truck drivers and other vehicle drivers, bus drivers, etc., or even others, they may consume liquor and have drive while drinking, then it may lead to accidents and loss of lives. So just to save those loss of lives, now, on the one hand, that was a human right angle in the mind of the court, but on the other hand, it led to thousands of such vendors rendering unemployed on the one hand, and many others who lost their jobs, those who were working there. So the question was, on the one hand, there is this human right aspect. On the other hand, there is an economic aspect where to strike the balance. I'm only flagging the issues for your Then about the diesel vehicles, where the order was passed some years ago, seeing that they were creating pollutions, and diesel vehicles with 2000 ccc should not be permitted or should not have license in Delhi, where there was a pollution. But question was, now another aspect which is, and here also the economic factors came, and on the one hand we are talking in the favor of environment and in favor of pollution, but on the other hand we are giving a setback to the economic activity. So where to draw the balance in such cases? And when we talk of environment, and the entire concept of sustainable development, I would say, is based on economic principles, that there should be development also, and at the same time it should be sustainable, and not that at the cost of environment you have this. But again it becomes a matter of this balancing between the two. So therefore these are some of the challenges which the judiciary faces, will keep on facing. But what I feel, and I say, and that would be my appeal to Dr. Ranita Nagar, because she has done wonderful work, and Professor Ram Singh from Delhi University, and many others who have done wonderful work in India in this field of law and economics, that while training the students, that try to enlighten judges as well, that when the judges make the decision, they are conscious of the economic effects of decision making. They are conscious, they should be conscious of, and it should not be only in a subconscious manner. They should be conscious of the economic principles, which if they need to be applied in some of the decisions, that should be done. Thank you very much.
Thank you so much, Dr. Sikri, for accommodating your schedule for us and gracing us with your presence today. As we come to a close of this inaugural ceremony, I wish to thank all the luminaries present amongst us today, as well as all the participants present today. With this, we come to an end of the inaugural session. And I again thank all of you for being here today with us. Sanjay sir, Justice Sikri, Professor, Director sir, Mamta ma'am, everyone. Thank you so much, everyone. Thank you.
I'll just put in the last word, Justice Sikri sir and Prasad sir. Thank you so much for setting the note for the conference. The tone of the conference should and must be the center of the debate between efficiency and equity. I keep telling students in my class, distribution of this efficiency. Efficiency is a good concept, but if distribution of this efficiency is what a welfare state is about. And also, Prasad sir, thank you for bringing that, connect in that post 1990s, it is mainstream neoclassical economics that has taken over, which has mainstream neoclassical. This is also something that we do tell our students. So thank you for setting the tone, and we will be looking at distributive and welfare aspects, because there is the whole mainstream economics is dominated by the efficiency argument. With those words, thank you so much for gracing the occasion. Ishan, over to you. Please conduct the next program. Thank you, Professor. Thank you,
Thank you, ma'am.
Sir. Thank you, Dr. Thakkar. Thank you, Mamta ma'am. Hitesh sir, please, sir, 2 words before concluding.
Yeah, so thank you, one and all. I think we are thankful to Honorable Justice Sikri sir. I think he's a mentor, he's a guide. I think even we were not knowing law and economics, and in fact his judgment and everything gets motivated. And I was just going through sir help to us, like, and I think in the international conference for law and economics, which IMH organized, and he was the keynote speaker. So I can't forget the way he has correlated this trade-off between efficiency and equity. And he told not it is only equity, but it is also about justice. And the firecracker case, I think that time it was decided, and so many questions were there. But I think the way he has explained, I think I can't forget it. And so I'm teaching this concept using your example, and I have never forgotten that thing. Sanjay Prasad sir, I think what to say, sir, the way you have simplified and way you said that it is not about the subject is not about the technical and complexity. The subject is about the human being and the people who are living in the field, and wherever the problems are there, I think it has to be taken care. It's not creating confusion and not reach to anywhere. I think the way you have told, I think it was things we are also doing in that regard, and hopefully the center is making sense on that. And I think you have covered all the aspect what we were thinking, and I think it's great that you are knowing better than us law and economics. That's what I can say, that despite of having a formal training and that, I think. And the Dean Mamta madam, I think madam is teaching IBC, and I think before that, I think madam was teaching a family law. So there are two aspects which do take care. So IBC is purely from the economic point of view, but from the family law and other are from the broad point of view of the different framework of economics. So I think the way madam interact the law and economics, I think it's great, and I think the way madam has simplified and told many things about the conceptual and even the relevant part, that not only the the justice was economic justice, and I think simplified in point of view of the marginal benefit and marginal cost. And I think it was great, madam, to listen to you. And I think always when we listen, I think we learn something new from the law angle. And I feel that what Santa Kumar sir was saying, sir was making clear that that the law faculty and the other stream faculty, maybe social science, science and technology, or maybe commerce and management, they are really a great partner. And one of the example can be the friendship of Mamta madam and Ranita madam from the point of view of law and economics, and similarly maybe point of view of some of other colleagues friendship with others. I think the way we are learning from each other, and way if we can jointly contribute to each other, I think this subject can be developed at the other angle. I don't want to miss out the thanking the Sri. I think his job was very tough because sometimes technology do create problems. So he don't have any control. But what to do? Sometimes he get in a problem. But I think still he has managed the properly. And the Isan, who was the a student convener of the conference, he has done, I think, delicately job. The background work day and night from last 15-20 days happening, I think is only Isan who is doing. And sometimes I also do take credit. I think everything goes to everyone who are helping us in the law and economics. And I think I'm really thankful to Sikri sir, Prasad sir, Mamta madam, our director sir, registrar, our all faculty member, our student center member. I think they are working day and night. And I think what we are doing, I don't know whether we are doing meaningful contribution or not, but we are enjoying, and we are enjoying this journey, and hopefully we'll come out something more meaningfully, as Sikri sir has said, Mamta madam has said, and Prasad sir has said, and even our center head, Ranita madam has said. With that note, I think I have extended time, but you don't give me a vote of thanks. It sometimes it go beyond the preparation. But thank you very much. Thank you.
Thank you, sir. Ma'am, and you have certainly been our guiding force behind this conference. I thank each and everyone present here today. And with this, we come to an end of the inaugural session. Thank you, everyone.
Thank you, Ishan.
Thank you, everyone. I would request the participants and paper presenters to kindly proceed to the technical session links now, because we'll be closing the inaugural ceremony link for the time being. Thank you, everyone.
Yes. Technical sessions 1 and 2 are underway. Please join in accordingly.